Again, welcome everyone to Special Education Law and Strategy 101. I'm here today with Lisa Schiltz and Andrea Jepsen. We are recording and I'm going to share a PowerPoint presentation for those who are joining us online. You should be able to just click to a forward thinking.
So, welcome everyone. I'm really excited and pleased that you are here, and Andrea and I are really pleased to be able to talk to you guys today. We thought we'd just start by telling you our stories, what brought us here a little bit, each of us, and then talk a little bit about where we're going with our clinic, and then we would like to keep you comfortable, give you an opportunity to tell us why you're here too, because we all probably all the same members whereas probably love somebody to do it. So it's nice to have a sense of where we are, where you are in your journey. So I'm Lisa Schiltz, and I have a son with Down syndrome and autism and verbal apraxia and epilepsy. And he is now 27 years old, and he lives with us and he goes to the day program. He does really well. He's lovely. He's a letter of life, so many ways. He has introduced us to worlds we never have experienced. When he was born, my mother, who also raised a son with disabilities, first thing she said to me on the phone when I told her was, "Oh, Lisa, you're going to meet such wonderful people." And that like really struck me as a weird thing to say, but it turned out to be really, really true. So it's been a journey, but the unfun part of the journey was always dealing with all these laws and dealing with IEPs. And every year having to confront the fact that having to really confront your kids' disabilities head on again, and confront the fact that you don't know, you don't have the expert in how to teach and make it the best out of your son. And even though you're a lawyer, you don't understand these laws, and you just don't have the time to really figure them out, and you feel guilty about that, and you're beating yourself on the head for not doing a better job. So I've been through 27 years of that with my son. And the whole time, a lot of the time, I would talk, and my husband and I, who's also a lawyer, we would talk about how people are learning to do this. And we just more and more, as the years went by, we got into something, we got into people. And that's what the clinic is all about. So maybe Andrea, you want to tell a little bit about your story? And I would be happy to.
Absolutely. I'm Andrea Jepsen. I went to St. Thomas for law school, and I graduated in 2006, which was the third graduating class. I went to law school because I have a child with a disability. He is now also 27. His name's Jack, and he has autism, and he's very comfortable having me talk about him and his disability, which makes me feel like I did, maybe at least one thing right. And I went to law school because I knew that my son was going to need legal help. I did not expect that I would practice education law, but he was a kid with very serious behavior problems, and I thought he was going to prison. I mean, I say that as a joke, but he really was so disordered. And so I felt like I really needed some skills to meet his needs, and I was also a single parent at the time, and I was getting a lot of calls to get my kid. He was causing a disruption in class, and so having some place where I was in a more flexible setting than a 9-to-5 job ended up making good sense for me. I ended up practicing in a legal aid organization after I graduated. Not only was I not really ready to practice special ed, but I don't know. It really never even occurred to me at that stage. As much as I understood the laws, I didn't really understand the law. I didn't grasp, I think, the practice very effectively. But I spent some time working quite a bit with people with disabilities at legal aid, and then I went into private practice doing education law, which was primarily special ed law, but also some disability discrimination, and then also suspensions and expulsions, a lot of disciplinary work. And then when the pandemic hit and we were all just sort of derailing, and my son was having a hard time, I thought, this is a practice that's getting so hard, and we will talk a little bit about that school districts have gotten so aggressive. The courts have been in many cases, at least in this circuit, so unfriendly to these claims that I just thought there really has to be a better way to do this. It occurred to me, Lisa had been very interested in starting a clinic, and it occurred to me that that really was the only way that our kids, because I know for many of us who do have kids, were going to find any justice, and that was to increase the number of people who could promote these claims and accustom the courts to hearing from parents with disabilities. So I'm super excited. Should I say anything about what we do in the clinic, or would you like to? Okay. So, I mean, a clinic is a challenging situation because you only have students for a certain period of time. And neither Lisa nor I really want to be private practice attorneys who occasionally have law clerks that come in but don't really have any experience. And so what we decided we could do is take on what I believe is the most pervasive problem in special education, and that is unmeasurable goals and objectives, and then the lack of measurement of those unmeasurable goals and objectives. So we have been working with a private school, excuse me, St. Peter Flavor, which is a small Catholic school in St. Paul. And the children there, many of whom have special education needs, are receiving their services from the St. Paul School District. And so we're working closely with St. Peter Flavor in order to review the IEPs of children that are attending there and receiving services, to consider whether those IEPs are structured such that a kid can make progress and that progress can be measured so that we and the parents can participate in the educational decision-making process. And we're just kind of starting and feeling our way, but so far things are going well. We had 2 students last year in the clinic. We have retained those students, and I believe 5 or 6 were put forward for this year's 20 students. So what we'd really like to do carefully, very carefully, is to grow and try to produce as many practitioners as we can to encourage as many people who are interested in becoming lawyers or may already be practicing. That a special ed practice could be a way to distinguish yourself in whatever area you happen to be practicing right now. So far, good results, and we're excited and excited to be here. So thank you for coming. Do you want to briefly, if you feel comfortable, just say who you are and what you do?
So my name is Dana Gerber. I'm here. I have a daughter with single-sided deafness. And it's kind of a unique disability that we have her IEP meeting tomorrow. And so I was like, okay, well, I don't know a luckier thing. So
I am Monica Gould, and my son has dyslexia, dysgraphia, and we went through the IEP process, and even just getting to that stage was a battle. And so it was, I think this is extremely timely. And like you said, people without legal backgrounds, without knowing sort of what their rights are, what the laws say. I don't understand how any family can navigate the system without having resources like the 2 of you to call and say, help. So it's, so yeah, I'm very interested in just learning more and going through that.
I'm Allie Palmer. I have twin boys, one of whom has an IEP for ADHD and anxiety. Really struggles in school. And my husband and I have had very similar conversations, like how do other people go through this process? And we've had many frustrations where we felt maybe we weren't being listened to, and we heard a lot, well, we can't do that because of special education laws. And admittedly, I didn't follow up with the question, right, which I probably should have done. But I just kind of took that for a while, and I'm not willing to do so anymore. So I'm here, to be educated and find out what laws we're talking about and be able to better advocate for my kid.
I am Paulo Castro, USC class of 2021. I'm an attorney working at the Disability Law Center with special education, and I feel this is an opportunity to, for the first time, go over the special education system in the classroom setting.
Hi, my name is Ryan Hainsey. I'm a legal advocate at the Disability Law Center. I'm also a person on the autism spectrum. Prior to this position, I was a special ed teacher in both St. Paul and Minneapolis Public Schools, so I have a background in special ed for, 10 years. I taught for 6 years, and yeah, I read a lot of IEPs that were not measurable, from former special ed teachers, and now being an advocate with, parents, families, and clients with special needs, and I'm doing a lot of, advocating for paperwork type issues. I'm reading even worse and very unmeasurable IEPs, and you wouldn't believe how insufficient and illegal they are.
We would actually.
And I'm Sonia Peterson. I'm with the Minnesota Disability Law Center too. I'm a litigation staff attorney there. And I've been practicing long enough that I would think I would have handled a case under the IDEA before, and this is my first time.
Wow.
And it's kind of like, I need the basic strategy 101, because we've got a class action where the federal state law does not comply with the federal standards, and we're trying to get that improved. And I'm just working, with the individual plaintiffs in this to try to get it recognized. And the legislature says they want to do something about it. Now with kind of the change in the status, we might actually get some movement this year.
I'm interested in talking to you, Sonia, because I think that is the future of special ed.
Okay.
education, is suing the state.
Okay, good.
Oh, me.
Oh, I'm Katie McRoy. I'm just a mom. I have no legal background, but hats off to all of you because I have 2 kiddos. Both have Down syndrome. One is a dual diagnosis with apraxia as well. And he's my older, and I've been through many IEPs with him where we actually hired an attorney. Because I was at least smart enough to know that the things they were telling me were not legal. And when I would ask them to put it in writing, they would end the meeting. So we had about 20 meetings in a 6-month span with an attorney present to get with it.
That Florida?
Yes. Wow. Yeah. And thankfully I have lovely Kristen here as my neighbor who will have me with my next one. It's our kids are the same age and we'll be going through the same process.
I'm Kristen Yankee, St. Thomas alum, 2012. I'm practicing in Northfield and do transactional law, so estate planning, real estate business, and I do some, prior to my son, did do some special education or special needs planning and guardianship. So I'm starting to, I don't market that a lot, but I'm getting a lot of referrals, and just in my area, I think I'm the only one that's practicing there. So I'm interested in expanding more into it. My son, who will be 3 at the end of the month, has Down syndrome, and we just actually got our first IEP in writing 2 days ago. And it's with anything, right? You don't know what you don't know. And so I'm trying to educate myself because I want to know what I can push back on and what, and so, and thankfully our district so far has been wonderful, but they also want to know. They're really great and they're like, we learn things and we're doing something wrong, tell us and help us. So hoping that I can advocate best for my son, and then also interested in if there's a need to help other families.
I'm Brenda Erickson and I'm working on CLEs, and it looked like an interesting topic.
Great.
I'm Gloria Myrie, Director of Alumni Engagement and Student Life, and a graduate in the class of 07 with Dina. And as I mentioned before, I have a son who is in middle school and is on the spectrum and has ADHD and anxiety, and he has been on an IEP since he was in 3rd grade. So we're just doing our first review this time and this year. And so I took a call from the IEP manager out in the hallway, just as all of you were walking in. So very, thank you.
Hi, I'm Abby Lloyd. I'm pretty new to the law school. I'm director of development, so I'm here mostly just to learn, but coincidentally, my mom was a special education teacher in high school for 30 years. So I heard other, ends of the story, and certainly something I've experienced with friends who have had to go through this and heard them struggle and connected them to other people I knew just because they needed that coordination, that support. So I'm like excited to hear what's going on and what people are doing.
Great. Well, thank you. Welcome, everybody.
Okay, let's get started with some more of the substance now that we kind of know who we are, what we're dealing with. And the first thing that I want to do is give you some background, some historical background of the idea, right? The Individuals with Disabilities Education Act, because those of you who are professionals in the area, you know you're doing civil rights work, but there are also of us who are just parents. We forget that sometimes. We think, oh, we're trying to like get the best thing for our little particular kid, but we're really in the middle of a huge civil rights struggle. And that's what IDEA is a really important civil rights law that we have. And so how do we even get the idea? How do we even get it? It starts off really with the story of Brown v. versus Board of Education, right? Where we know the Supreme Court said schools had to be desegregated and overturned that separate but equal was okay. You couldn't segregate children by their race in public schools. And you also know, probably most of you, that when you win a big Supreme Court case, a civil rights case, that's not the end of the story, because there ends up being a consent decree whereby the school or whoever loses the case is basically coming to a settlement. How's it going to make the changes that the court said they had to make? And so for years and years after any kind of litigation that's that impactful in a civil rights area, there will be, the court will retain jurisdiction, the district court, to monitor how the schools are actually doing. And after Brown versus Board of Education, the schools did horribly, right? There are all kinds of consent decrees all over the country saying, this is how you're going to desegregate. This is how you're going to manage to do it. And one important one here was in 1967, the Hobson v. Hansen case in the District Court of DC, which was showing that people were still trying to keep segregation, racial segregation going, but they were using disability characteristics to do that. So there was biased aptitude testing. They were tracking students of color into segregated and inferior schools, and they were using disability as the means, the vehicle for doing it. Then gradually we had parents who were parents of kids with special needs who saw Brown versus Board of Education and said, why are our kids still being segregated? If they are lucky enough to be able to be educated, they're in separate schools, isolated from everybody else. But honestly, for a large part of them, they're not even able to be educated because they're put into public institutions. The big fight in these cases was to deinstitutionalize people with disabilities, to shut down the asylums. And the wedge strategically that the Pennsylvania Association for Retarded Children found, the way they would start doing that was with education. With this idea that let's talk about little Johnny or Billy who's living next door to you. You know, why can't they start out in the public schools? And this was the first big case in Pennsylvania challenging the state policy that conditioned access to public schools to reaching a mental age of 5. So you could not go to public school in Pennsylvania unless you could prove that you were mentally 5 years old. Fought that and won. Huge victory, right? Shortly thereafter, there was Mill versus the Board of Education in 72 in DC. And their court there held that denying education to children with disabilities violated equal protection. So these were big, huge civil rights cases, and they laid the foundation for the idea. In fact, the consent decrees in those cases used language that became part of the statutes that we have right now. The consent decree in the Park case says, it is the Commonwealth's obligation to place each mentally retarded child in a free public program of education and training appropriate to the kid's capacity. These are all words that we're going to be hearing. They're in our idea. That's the free and appropriate public education right there. Carolyn's got. LR, the least restrictive environment, they also said placement in a regular school is preferable to placement in special school, and placement in a special public school class is preferable to placement in any other type of program of education or training. So this became the roots of idea. The Mills case expanded it. This was the Park case was just for mentally retarded in that language kids. The Mills case expanded it for all kinds of people who are being denied enrollment or expelled for mental, behavioral, physical, emotional disabilities. And a really important thing here, they rejected the district court's argument that they didn't have the money to do it.
rejected way back in 1972. He said, if sufficient funds are not available to finance all of the services and programs that are needed and desirable in the system, then the available funds must be expended equitably in such a manner that no child is entirely excluded from the publicly supported education consistent with his needs and ability to benefit therefrom. The inadequacies of the District of Columbia public school system, whether occasioned by insufficient funding or administrative inefficiency, certainly cannot be permitted to bear more heavily on the exceptional or handicapped child than on other children. That's another principle that's part of, again, you have the rights that you have. And the school saying you don't have the money is never an excuse. Never was from the very beginning of these cases, okay? So these are the laws that we eventually have that turned into the idea. You'll see sometimes references to some of these other names. And this is what the statute used to be called, or what some of the other statutes were. But gradually over the years, we received the education for the right to have education for all of our children with disabilities in the public school system. And these laws were, it's over a period of time. They're signed by different presidents, right? I think President Nixon signed that one, Gerald Ford signed that one, I think Herbert Walker Bush, that one, Clinton, that one, and then George Bush, that one. I mean, and these were, pretty bipartisan efforts. But the problem is something that the problem of things that still exist today, still grapple with today. If you read some of the testimony in the hearings for the enactment of idea of the education of handicapped children, you'll hear people say that things that we are still hearing today about the special education system. All kinds of things, right? And one of the things that you will hear a lot about really is the inadequacy of the funding mechanism for special ed. You're not gonna know these, but I just want to show you a little bit of the story. When the Congress passed IDEA, they promised that they would fund 40% of all of the expenses of doing the things that the law was telling the state they had to do. They have never fully funded IDEA. The most people, maybe at one point they funded 20% of the expenses, but it's generally now something like 16%. So the state has to pay the rest of it, right? So this is an unfunded mandate, right? For a while we thought we didn't have any of those, but we do have this. And so when you hear things from the state, you should recognize that they get some federal funding, but not nearly, it's not nearly funded fully. Every state has its own mechanisms figuring out how to make that shortfall, which explains the really wide disparities in special ed in different states. So that problem was flagged in the original hearings, and it continues to be an issue that there's a mandate there by law have to provide when the law says you have to do, but they don't have the funding for it. The other second thing that's complicated that we just want to flag for you at the very beginning is to the recognition that IDEA is a mix of federal and state law. We have the big federal law that says this is what you have to do. If you want to get any funding for special education, you have to follow our rules, big instructions. And then you have Department of Ed regulations. But then every state writes its own law about how it's going to do it. It refines the definitions. It puts specifics into the categories of people who qualify. It changes some things. That's the Minnesota law, and then we have Minnesota regulations as well. So I think that's it. I think I'm going to turn it over to Andrea now to keep moving. Let's start.
Well, I'm hoping, one of the things that we could have done and didn't, was to put page numbers on these. We'll do that next time. So if you would help me keep track of when it's your turn to take over again. As I said, I practiced in this area. There is a desperate need for practitioners. So if that's your interest, I'm always happy to talk to folks who are interested in practicing in the area of education law. And even if you're a transactional attorney, there are very important ways, critical ways that are non-litigious, that attorneys can support and train attorneys who practice in this area. And I understand that, I think it was Kristen who said you're in our field, and although I am disappointed to hear the school district say, if you learn something, you should tell us, because those are the folks who are supposed to know the law. But we really do hope that we meet people relatively early in their journey, because as a general rule, that is when school districts are responsive. They are willing to make changes. And if you come as an informed parent or practitioner and you come early, you just don't have years and years of distrust to work through. You don't have years of educational failure that you're sort of emotionally wrestling with. To my knowledge right now, we have for legal aid attorneys, Paulo, we have his brand new supervisor. Smurls has some folks, but the last time I checked in with them, they weren't litigating. There's probably some non-specialists who practice in the more remote legal aid organizations. The problem is that education law, special education law, and discrimination law, which interact with each other, is a really, really broad and deep area of the law. So it is hard to dabble. It's hard to do a lot of different kinds of things. I am aware of right now one full-time private attorney practicing exclusively in this area in Minnesota and the Dakotas and Wisconsin. I am aware of one attorney who I understand is doing some special ed work in the Dakotas. I am not taking any more private clients outside of the clinic. I do not know of another legal special ed clinic that's operating in Minnesota. So the reality is that there's a ton of kids who just aren't going to get services. In Minnesota, yeah.
So what are your thoughts on Pacer group?
Yeah.
And the services that they provide?
So I came to law school because my Pacer advocate went to law school. So Al, you went to school with Susan Sugar Smith. She was my Pacer advocate over 20 years ago.
Yeah.
And she came here, she was in the first class. She was, well, first of all, you have to go to law school. Second of all, you have to do it at St. Thomas. I think that it's an extremely important organization that does good work, full stop. They will tell you they're not attorneys, and they aren't attorneys. They're not. I would like to develop a closer relationship with Pacer. I'd like to train their advocates more effectively. As I understand, they're starting to move a little bit more towards bullying and doing less special ed work. That may be incorrect, but I think their utility is limited, and they're most helpful. Any advocate is most helpful when what you need is somebody to still your spine, not as much when you need an attorney to help you understand the law.
But also they put on great programs that I've gone to a bunch of them, and I think my son doing technology assessment, they have a technology. They were really great. You got them into all kinds of stuff. And I've been I went to training for housing, for guardianship, they all have a lot of.
Absolutely. Absolutely. They have a puppet program. Have you ever seen this? Oh, there are puppets that are in like wheelchairs, and I mean, there's like an autistic puppet, and so they'll bring puppets out in the school. The puppets do bullying work. They do theatrical productions around bullying. Very committed, very committed puppets. So doing their bullying work. But they're an excellent organization. They aren't attorneys, and they can't take the place of attorneys. And we talk sometimes about why aren't there more attorneys working in this area? And I think it is because it's a relatively new law. I mean, it's not a new law. I mean, it came into being during my lifetime, but I'm not a baby, right? But in terms of, it's not property law, it's not family law. It's just not it's a contract law. It's just not a very old law. And over time, we are starting to view. We're looking at the tent of disability in a broader way. So I think that people are now coming into law school who have been served under IEPs. And so probably seeing a little more interest in the practice area in that way, but there's a desperate need. And what I tell people think it's a joke, it is not a joke. You should go to law school. No, it's not. You're absolutely fine. That's all I'm doing. You can do it. Right, people should go to law school.
I do have a question.
Yeah.
My experience is from Florida,
Right.
and now here, and I was under the impression that every state has it, so I'm wondering if Minnesota does, but we use disability rights Florida with the attorney that was provided for us for when we have.
Right.
Meeting. Does every state have?
Yep. So it's called the Protection and Advocacy Group, or the PNA, and Paul works for the PNA. And until October, he was the only attorney in the state, representing kids with, where I have no idea what to do now. I'll get you there, don't worry. All right. Anyway, so the point of all of that is that there's, no worries. There, that's a lot. I didn't. Okay, there we go. Very smart. And the violations are extensive. So I will tell, I cannot tell you how many hundreds, thousands of IEPs I've looked at. I've never seen one that complied with the law, not once. So that's our hope. At the special education clinic, we can teach folks who want to learn how to be educational law attorneys more broadly, and special education attorneys more specifically. So one of the things that I think you don't learn when you're learning about special education law, if you're lucky enough to learn about special education law, is that there's a destination in mind. So if you're a parent and an IEP is being developed and services are being given to you, you oftentimes wonder whether those services are adequate. You wonder if the progress, which is what in many ways special ed is all about, that your child's going to make on goals and objectives is going to be enough. And the way you figure it out, it's an inexact science. But the way you figure it out is to consider what the whole point of the idea is. And that is, in short, to maximize your child's independence. We are expecting that children will be able to live and work as independently as possible within their communities, that they'll be employed if possible, that they'll go to school if possible, that they'll live in their communities and have independent, enriched lives. And so we work back from that when we consider the kinds of goals and objectives our children should be getting and the services that should accompany them. And Lisa's right. We hear, the school district doesn't have enough funding for that, doesn't have enough services. And it doesn't matter what your child gets is what your child needs to get to the end of, to get to the special ed destination. All right, so we're going to talk today, and I think we could probably chat for a really, really long time. So we're going to try to move quickly and then kind of stop on what I think are some pressure points. But we'll talk about identification, evaluation, how children are determined to be eligible, what goes into the development of IEPs and how we decide where children are going to be receiving their services. And then very, very, very importantly, how we identify whether our child is making progress. And the two areas I think where schools are weakest and parents tend to be most in the dark is how to truly how to understand whether what it is their kids are going to learn and whether they actually learn what they were supposed to learn. All right, so identification is fascinating, right? Because it's it's like a strict liability statute. School districts have to find kids. And one of the things that we're finding out at St. Peter Flavor is that they're not finding kids. So kids are, I just talked to St. Peter Flavor the other day, and they have a kid went from St. Paul to St. Peter Flavor back. I guess that got St. Paul to St. Peter Flavor, and now they're looking to St. Paul for services. And St. Paul is saying, well, who's this kid? We don't even know anything about it. So schools have an absolute obligation to find kids who might be eligible for services. And it doesn't matter where they are. It doesn't matter if they're in private school located in the school district. It doesn't matter if they're in prison. It doesn't matter if they're homeless or they're just at home and they're not going to school. And it doesn't matter that they're in private schools. And we won't talk about this much Well, we won't talk about it at all, except to say that Minnesota is a very unique state because to my knowledge, it is the only state where children who are enrolled in private schools are also entitled to the full range of services for special education. So they're leaving the private school for those services. There are issues about location and timing, but there is no other state that I'm aware of where children get to have all of the necessary services, even when they're at a private school. And in Minnesota, we have obligated schools to find children at birth. So for those of you who have children who have Down syndrome, right, identifiable at birth, the idea is that the school district would come to your pediatrician and say, listen, we want to know if you identify any kids who have disabilities at birth, because we're going to want to start giving them services if the parents interested right away. And if I remember correctly, the federal standard is 3. I forget, I mean, Lisa is, you know, the gifted scholar who has a better, no, she is, a better sense of sort of the, you know, the elegant history of things. And I'm just like, I'm karma here, right? So I sometimes will forget, is it Minnesota? Is it federal law? Don't care. I practice in Minnesota and in Minnesota it's good. Is this me or you? You're gonna tell me, okay, we will definitely put page numbers on next time. All right, so after, when a kid is identified, the next step is for the kid to be fully evaluated. So there are timelines that the school district has to respect. So an initial evaluation has to occur within a reasonable time, but that timeline can't exceed 30 school days from the date the district receives permission from the parent. That's a really long time. I mean, when you have a kid who's waiting for services, I've never seen a school district conduct an evaluation in a reasonable time that was less than 30 school days from the date the district received parental permission. The evaluation has to do 2 things. The first thing it has to do is to determine whether the child is eligible. I'll talk about how you make that analysis. So eligible for services under the idea, and then also has to evaluate whether all of the children's needs. So these are really comprehensive evaluations that will involve a lot of different specialists. So they have to uncover these needs, whether they're common to the disability or not. And then at least once every 3 years, or if there's been some kind of change in the child's condition, the child isn't responding or making progress, it would be a very appropriate time to do another evaluation. Or if a parent or teacher requests that there should be an evaluation, but there is typically not one done more than 1 time per year at parent request. All right, yes.
The initial evaluation is supposed to be within the 30 days after the district receives the consent, but this, yes. So there's re-evaluation if the parent requests because of a change in diagnosis. Is there a time frame or there's no regulation for it?
I don't know off the top of it. I'd have to look at the statute. So I've been teaching this, I've been teaching the clinic and I've been teaching an advanced placement student. And one of the things that really strikes me is how many things I've forgotten or I never really knew. It's a really, really vast area of law. And as a practitioner, it's very appropriate and common to have to say, I never really ran across that. I have to look it up. So I don't know. Off the top of my head, it's not going to be longer than 30 school days, that's for sure. And my guess is probably 30 school days, but I'd have to check it. Sorry, I didn't skip one, did I? Yeah, I did. How do I go back? Maybe just really? I put my hand on that. Oh, see, little arrows. I think this is it. That's where you. Oh, so there. Excellent. Okay, I was just sort of randomly. Okay, so the determination of whether a child is a person with a disability is a pretty dry and calculated analysis. And it is a place where parents can get, pretty emotional and pretty frustrated, understandably, but it's kind of a cookbook type analysis. So there are a variety of eligibility categories that are described in Minnesota state regulation. Your child may be receiving an evaluation to identify the possibility of services under a number of eligibility categories. So maybe Peter, Lisa's son, would get a developmental delay, or would qualify under developmental delay, but also might qualify under a speech and language condition, right? Or my son with autism could have been identified as receiving services under the autism category, under the ADHD. Well, really, it's well, you could have yeah, the behaviors too. It's the I lost the acronym. But,
EBD?
What's that?
EBD?
You could have gotten EBD. It's it refers more generally to a collection of medical conditions, one of which can be ADHD. It just I lost it.
OHG.
OHG
Yeah.
or OHI, exactly. Thank you. And what does that stand for?
Other health facilities.
Yeah, for other health impairments. One's the state and one's the federal law. And it doesn't really matter, frankly, what category your child qualifies under, as long as all of it. What's that? Because the school is very different. Why do they think that?
Like, my son has one loss, other health impairment.
Right.
They wanted to be like.
Okay.
They wanted to deny that,
Why?
but they was saying we need to be under DB.
Okay.
So that, I'm just saying,
Yeah.
I'm just saying that this is what they're telling families.
If I were your attorney, I would not counsel you not to do IQ testing. And you want to know about all your child's needs.
Right.
And in the end, what really does matter is what ends up being in the
But
IQ.
I'm not saying that it doesn't matter which qualification, because they.
In my opinion, it's right. So these, I have seen occasions, however, where Minnesota's eligibility qualifications have been more exacting than the federal regulations. So you should know it is possible for these regulations to be preempted by federal law. So when you're looking at whether a child qualifies, it's important to look at the federal eligibility categories, which tend to be a little less broad, and also the state eligibility categories as well. Okay. So the child has to be evaluated in all areas of suspected disability. And these are, this is not an exclusive list. So health, vision, hearing, social and emotional status, IQ, their ability to communicate, their ability to move, other kinds of academic challenges. And what I think is important to note about this is that a child's educational needs are not limited to their performance on tests. So we are concerned about how children are prepared to function in the world. Education is considered a broad category of needs under the idea. And the evaluation has to be broad enough and comprehensive enough that we identify every educational need that the child has. Okay. It's really common when you go to an evaluation report meeting, so they'll do the evaluation, then they call everybody together. It's very, very common to be handed as a parent your report as you sit at the table. These things are like 40 pages. That doesn't make any sense at all, right? And one of the things that you have to do is to make a decision about whether the evaluation is sufficient, whether additional evaluation needs to be done, whether your child qualifies, whether you agree with the data that's been assembled, and you can't do that while you're sitting there. You really can't do much of anything with that report at that time. So this is just, this is your practice tip, and that is that you should, in my opinion, never meet with the school district to review an evaluation report unless you've been given one, and I like it a week ahead of time. I like to go through it and chart and make note of the questions that I have. And so you want to, when you look at it, you want to think about what you know about your child, because you know more in many cases about your child than anybody else sitting at the table. So you know if there's something that's missing, that somebody's ignoring something about your child's condition and they haven't fully considered that as part of the evaluation. If you believe that the school district has performed an inappropriate evaluation of your child, you can seek what's called an independent educational evaluation, or IEP. So IEPs are evaluations that are performed by people who do not work for the school district. It is very common for school districts to say, I'm not interested, or we're not interested in having that person do this evaluation. They're not independent from parents. It does not matter. The only party that independent educational evaluators are independent from is the school district. And IEPs can either be initiated by the parent, or they can be, we say, provided at public expense. So the school district would be paying for that. School districts don't like to do it. So when you as a parent seek out a private evaluation of your child, the school district is obligated to consider the results of that evaluation in any kind of decision that they make about your child's about your child's educational needs and the services that your child will receive. If you are a parent who's interested in getting a private evaluation and paying for that yourself, maybe you have a health insurance plan that will pay for that, or you've decided that you've just chosen not to deal with the trouble and you're going to pay for this yourself. The school district has to provide you with the necessary criteria, the criteria they use when they're performing their evaluations. And that's important, and the regulation does say that your examiner needs to use the criteria that the school district uses. But realistically, there are areas of specialty that the school district, school districts don't employ neuropsychologists, right? School districts oftentimes don't employ communication specialists or reading specialists with the kind of expertise that you might want out of an IEP. So realistically, in practice, if that information or if that evaluation is done by somebody who's a licensed professional, they're using instruments that are commonly used in their field, they're interpreting those results in a way that meets a professional standard, school districts will typically not give parents any trouble about their IEPs. They may ignore them when it's time to make a decision about educational programming, but they won't tell you that somehow they don't meet the criteria. When a parent asks for an IEP at public expense, and this is, in my experience, an unusual request, school districts oftentimes don't know exactly how to handle that. There are only two responses that are appropriate from the school district. The first one is, yes, we will provide one of those for you. And the second one is no, and we will contact the state to set up a due process hearing. So at that hearing, the school district is obligated to defend its evaluation and demonstrate that its evaluation was appropriate. Although the burden is on the school district to demonstrate that its evaluation is appropriate, realistically, there is no, in my experience, there's no way to fight the school district's position without an expert who is there to make the argument that your school district's evaluation is inappropriate. So I think it's a little bit of an empty burden assignment. The school district, or sorry, the Supreme Court has spoken. This is the blonde with the curly hair from the 80s on the Supreme Court. The first woman, yes. This morning I did something just totally kooky, and I just say to my kid, like, I'm almost 53. Okay, I forget things. Sandra Day O'Connor says that independent evaluators provide parents with the necessary firepower to challenge the school district. So the Supreme Court has recognized how incredibly important IEPs are to children. In my experience, they're almost always necessary for a failing school program. They help us understand how to get kids out of the woods. They give us a good understanding of what the kids' needs are, and they also can guide us in terms of appropriate interventions for those kids. But sadly, in the same way that there aren't very many legal practitioners who are in a position to provide special education legal services, there are very few. There's an insufficient number of experts to provide independent educational evaluations. So you only get one of these every time that the school district does an evaluation. So you have to be thoughtful about what you're asking for. So if you have a kid who's generally not doing well, and you think the evaluation hasn't appropriately identified your child's needs or hasn't provided the school district with a route to success, you're probably asking for a comprehensive evaluation that looks like the evaluation that the school district performs. So your comprehensive evaluation might involve a psychologist or a speech therapist or a trauma expert or a specialist in lung diseases. So you just have to be thoughtful about how you ask for your IEP, because if you ask for a communication specialist and that doesn't do the trick, you don't get to go back and ask for a neuropsych eval. If an IEP is obtained at public expense, school districts are not entitled to place additional criteria on the IEP in order to pay for it. We worked with a local neuropsychologist who was he was a very assertive child. Actually, it would be wrong to say he was an assertive child advocate. He was an assertive advocate for the truth about the child. Rich Ziegler was his name. Is his name. And school districts would create like a Rich Ziegler exception. So carve out wherever he worked and say, we will allow anybody who's not at the U, or we'll allow anybody who's not located in Minneapolis. And if that's not a restriction placed on the school district evaluators, it isn't a restriction that can be placed on IEPs. A little bit here.
Just
Yes.
one last question. I'm not sure if you think the same way as I think, but for example, when requesting an IE, I think parents have also to be thoughtful at public expense. Actually, parents have also to be thoughtful about if the school requests a due process hearing.
Yes.
How am I going to handle this due process hearing? Because, for example, right now at DLC, we have a staff shortage, so we are not really available to provide full representation for every parent and for every client. So, if the school requests this due process hearing, they would probably need an attorney for representation, even though parents can represent themselves. It's pretty hard. So it's another thing to think about before like requesting the.
That's a really, really good point that I hadn't thought about. Parents should never represent themselves at due process hearing unless they're attorneys, unless they're special education attorneys, because they have the capacity to go to school. And they're extremely unlikely to be successful. And Dana may tell me she did it, which was okay, too successful, and I'm it's really impressive. But it really shouldn't be done. But you're right, if you ask for it and there's no attorney available, and now you're in a position where you represent yourself, but you've waited a month, which is interminable when you have a kid that has some needs that aren't being addressed. You're absolutely right. It's smart to consider consulting with the private bar and to see somebody's available.
And I've actually been through a situation recently where opposing counsel sent 600 or 800 pages of exhibits in a due process hearing where the parent was represented.
And was it just based on the evaluation? That was
About the whole process. It wasn't like an evaluation problem, it was another problem, but the school basically sent 800 pages for the due process hearing.
The process of litigating these cases becomes burdensome in ways that changed significantly over the time that I practiced, and full of hundreds and hundreds and hundreds of documents held that you need. So, a bunch of people can't get everything getting appealed, whether there's merit or not. When it comes to appeal, all the way up to the United States Supreme Court on fact matters. Just, you could, like, it's not unthinkable at all, you could have $1 million idea matter, but John's up and down, whatever the matters. Have to be, I think an administrative hearing for the year was cost $30,000 on average, if you're paying for yourself. And I think that's a lot of, I mean, that's because they don't sue very often. They can afford to cover these things.
And it's fun to recognize, I mean, all of you are, most of you are lawyers, and you know that for most laws, if there's a violation, there's somebody who enforces, right? There's the AG will come in, you've got the prosecutors, and in the administrative context, you have the regulatory agents, the banking regulatory agency that enforces it. There isn't anybody that enforces IDEA except parents. The whole law is structured so that your parent, you, the parent, can be the advocate for your child. From the very beginning, people raised questions about that because the parents were not given any support or any training or the resources to be that effective. But the whole system is set up so that the parents who are supposed to be protecting their children and are alerting the world to violations and then using this litigation to get redress. And the deck is so stacked against the parents. And part of it is knowledge, and part of it is financial. Andrea and I have conversations. Where are schools getting this money to pay these lawyers to take these cases through so many stages to produce 600 pages? And when schools are complaining about special education budgets and how much money you're spending on special education, one of our thoughts is that we need to research that a little bit and figure out where that's coming from, because it makes no sense. It's really difficult. You don't want to, as a parent, you want to have won your case. You don't want to have to go to court. That's kind of what we're about.
Well, it certainly sounds like they figured out that there's not enough people bringing the cases, so if they can tie them up, then they're winning, even if it's money.
Yeah.
But my question was more along the lines of, how do you know when you might want an independent evaluation? Like what, I mean, who even tells you what to know, what to look for, other than like, this doesn't seem right, but how do you know what specialists should be involved?
It's really hard, right? It's really hard as a parent. The first place is your gut. Are they missing something about my kid? Is there something else going on? When my son was born, I did everything a good parent should do to a little kid with Downs, and then he still wasn't talking. I was doing everything. I was only waiting for it. I was doing everything. And I kept asking, could you have something else maybe going on? Could you have autism or something? Because it was just stuff. And I was always told, no, he's so social. Oh, he's so funny. No. And I was living in Indiana at the time. And when he was 5, we moved to Minnesota. And every single first person that he met, every professional, his doctor, every speech therapist, would like meet him and say, I know autism. And as finally, yes, I was so happy that I got something else because Down stuff wasn't working and having 500 set of books now. But so I mean, if you think that there might be something missing there, you have to then follow your gut and then start with the advocacy organizations. Like I went when we moved here then to the big autism, not Pacer, but the autism, Fraser. Fraser, and they have advocates and they will help and they will, start. So I think almost every kind of disability has some kind of advocacy group. They can get you in touch with some kind of professionals who do that identification. And you could probably have an informal conversation, not spending a lot of money or doing some kind of informal assessment. But it's really hard. We're not the experts. Yeah. We don't know what the issues are.
When people come to see an attorney who specializes in this area, and the first thing we do is we look at the progress reporting and the construction of the IEPs, whether the child is making, or whether we can identify whether the child is making progress or not. Frequently, we can't tell at all, but sometimes we absolutely can, and most commonly we can tell the schools and objectives are being repeated. And so we assume under those circumstances that the evaluation is faulty, because if it had been appropriate, then goals and objectives that were meaningful could be generated from it. But we always had to consult with an expert. So it was always a matter of contacting Dr. Ziegler or Dr. Richley, or contacting a behavioral expert, or contacting a communication expert. We couldn't tell substantively whether there was a problem. We had to talk to somebody who was in our stable of people who really knew it.
And a lot of times the special ed teachers are really good resources, and they know your kid and they recognize things. It's scary for them to sometimes talk about it, and they have a good relationship with them. But a lot of times they can ask the right questions.
What about the child with ADHD and anxiety?
No, she has single-sided deafness. So it's just one-sided, has its own challenges. Like they tested her and she couldn't hear any of the testing because they couldn't stream it correctly. So she sat there for 2 hours without being able to hear anything.
When we talk with them.
Yeah, I love them, yeah.
Any other questions about the assessments before we go on?
I have a quick one, right? For the IEEs, is there any kind of timing constraint on that? Does it have to happen within a certain amount of time?
No, in fact, there can be no time constraints placed on an IEP, because the department recognized that private practitioners can't be made available on the same schedule. But the only time when it can be challenged is that sometimes hearing officers will request as part of the hearing, as effectively the witness for the hearing officer will ask for an evaluation. Or practitioners will be bringing suit, and you're kind of operating between this tension of not wanting the statute of limitations to run out, but also needing to know what your remedy is. And so you aren't obligated to wait to know what your remedy is and to file. So then there's this huge push to get it done, but there's no strict timeline that has to be respected.
I have a question on the IT testing. So my son is turning blue, so I'm not really there yet, but I talked to another mom at an a mom who has a 6th grader with Down syndrome that is in all these Facebook groups for inclusion and gen ed settings, and she was saying like, you don't want to do IQ testing because the school's using it against you to try to make your kid go in special needs classrooms and go on to gen ed. That's like it seems like that's consensus.
That's really bad advice. You might feel different as a parent, but I think, I mean, well, you tell your side. So, I mean, it's all, I remember when I had a child, okay, and I was really, really concerned about, would there be interventions that would lead to some kind of outcome out of people, right? So, I went to this sort of like crunchy prenatal, or not prenatal, but crunchy birth mother class, and nobody wanted a doctor because they were afraid, well, we'll end up with all these things you don't want. And I say, you do have the ability to say no at any point. You don't want to be afraid of data about your child because it helps you understand what your child's needs are. And it's up to you to say, yeah, I get that you say my child has this kind of IQ, but I still demand more. Not knowing how your child's brain functions, because what if you're underestimated, right? So you want to make sure that IQ tests are done by people who can really carefully evaluate your child's intelligence without relying on means that might be exclusionary, right? You want the right kind of person to identify, and IQ is less important, frankly, than a more global sense of how your child's brain works, like a neuropsych eval. So understanding, maybe your son's IQ is 75, but he's got super fast processing speed, but he's got a challenge with, working memory and understanding the fullness of your child's intellectual functioning, and, how you might accommodate and how you might grow, I think is just essential. Other folks will disagree, and I think Lisa might disagree, and that's good if you do. But I just think when people say, I don't want data about my child, I never see it black mom. I just don't.
I actually agree with Andrea, but just to flesh that out a little bit more, it's really important that the right person is doing the testing. Because you want, I just like knowing more about my kid. I mean, I had prenatal diagnosis and knew he had Down syndrome before he was born. I wanted to know, I wanted to know what I was gonna have. That's just how I react. And I think that it is, but I had an experience. He did the IQ testing. It just didn't bother me at all. It was just one piece of who he was. And he was classified, at a certain level. And then a couple of years later, they had this 3-year evaluation. And all of a sudden his IQ was a lot higher. And I was like, oh, that's cool. He's not smarter. Like I wrote a Christmas card. I think I wrote like a letter, and it went to his the ex-special ed teacher from elementary school. And she was horrified. She said, no, you don't want that. That doesn't happen. You don't just like get smarter and get a higher IQ. And you don't want them to be saying he is got a higher IQ because he'll get fewer services. That was kind of wrong advice too. But because the point is, they cannot slot him into anything because of his IQ. An IEP has to be a look at the whole person, what they can do, and what will benefit your child. It cannot be determined by a number on an IQ test. So if there's a school district who's saying, oh, every kid who's got less than an X IQ goes to that room, that's illegal, that's wrong. That's what you'd be afraid of. I do appreciate, and I do appreciate the impulse not to want to label your kid. And this idea that, if he's labeled with a low IQ, there'll be lesser expectations of him. There's obviously a danger of that. We're all against that kind of stuff. But I don't think that, to me, knowing where he really was and knowing more about him was more important than the risk of that. Because I really think that my mom was right. You're going to meet some wonderful people. Most of the people who are in this, teachers on the ground, they really do appreciate your kids. That's why they're doing this work. Maybe the administrators want to slot them into something, but that's where we as lawyers are going to not let them do that. So I do see, I can tell it's an easy thing to use, but if you ever hear anybody say that's where he goes because of his IQ, boom, just sue him. I mean, you
he goes into the special class. And I really could bring to our school.
Yeah.
I read told our district that we're gonna.
Yeah, I mean, I see how many due process hearings I've been to where the hearing officer's essential response was like, but this kid's. When you say, really can't be. In my experience, every kid who's been identified as having lower IQ, who's gotten not just IQ, but lower IQ isn't the whole child. It just isn't. My son with a disability is brilliant. He's so much smarter than I am. I don't know. Really, he just so much. It's not the whole story. But in all cases where we have sought data about the child's intellectual function, where the child's got a cognitive disability, we've always been able to look at it and say, see, that kid should be able to read. See, that kid should be able to do X, Y, or Z.
But that's only if you get this full of sort of neuropsyche down. It breaks down. This really good does, but if it's just an IQ test, and if you got somebody like the inexperienced person who or something.
So does that mean the parent should get on their own? Or does
No,
the school
should
provide
be.
someone?
Well, it probably has to, but no, these burdens are all the school districts, all right? The school district has absolute obligation to identify the fullness of your child's needs. Will you, as a professional person, probably have to go get that kind of data yourself? Yeah. And sometimes, very honestly, rather than, I can't tell you how many clients have said, well, you could let it ride on me, right? You've got your retirement fund set aside, you can pay that to me. Or you could just decide, you just want to pay for whatever it is. Because I don't even know you're in something that will end up being a value for you. So sometimes people do, and the other challenge of this idea that parents are going to be monitoring their own child education system or educational program is that as parents, we are tired. Right? We don't want to be parents and lawyers and psychologists and social workers and reading experts and date providers and PT and notes users. We don't want to be those. We want to just be the mom. We just want to be the moms and parents.
Okay, this is a good discussion, and that's really key. That's where everything starts. But then where do we go next? So we'll start talking about the IEPs now. Okay, so you all have experienced this. Everybody's had an IEP meeting, at least one, right? It's this huge table full of all of these people, these experts. The parents have the right to be there. At least one regular ed teacher, if participating in the regular education environment, at least one special ed teacher, an administrator who basically can make decisions about money, is supposed to be there. An individual who can interpret the instructional implications of the evaluation, and then at the discretion of the parent or district, other people who know the child. And these get translated into one regular education teacher. Maybe the band teacher will pop in. My son was in a band class for 5 minutes, sometimes during the course of the meeting. The special ed teacher would be there. The administrator would be one of the vice principals who could squeeze 5 minutes in, just pop in for a minute, and sign the name, right? So they can show that they were there and then disappear. Number 5 is usually actually 7 people. A speech person, at least for my son, right? It's huge, a team of people. You don't know what they all do when they're all sitting there. And then you can have this is your right to have an advocate that you want to have something your sister-in-law who knows your kid just for moral support for you. It's really important. It's like when you go to a doctor's office, you want to, if it's serious, you want to someone to take notes and ask questions with you. You can always do that. But these things are overwhelming and they're scary. And they're scary for us, and we're lawyers and we know how to argue. But imagine even for other parents, it is absolutely normal for this to be an overwhelming experience. But the theory behind it is that all of the people who know him have little pieces of good things to say about your kid and important information about your kid should all be together talking. But as I've described it, that's not really what's happening to people in family. But what are you supposed to be doing? You're supposed to be all getting together, sharing all this information, and then coming up with your plan. But what really happens? You sit down typically, and an already drafted IEP will be given to you, right? And there will be all of these decisions that they are just proposing, but basically you're presented with something that it looks like a plan. And as Andrea said, you need time to digest those, and if there's going to be a draft, which there really shouldn't be, because they're supposed to be talking about what they're going to be doing, but practically getting all these people together is hard, and that often happens. You should have time to digest it. But if the team determines that a child qualifies, if you qualify, then you get an IEP, Individualized Education Plan. And these are requirements from the law. These are the different pieces of it. And they're all really important. It sounds like gobbledygook words, but they're really important. A statement of a child's present levels of academic achievement and functional performance. If we're going to measure any progress, we've got to know where we start. In our clinic, this is the thing that is just most often missed. So when you see, and it'll be labeled that in the IEP, take a look at that and ask yourself, does that accurately describe where my child is? And is it meaningful? Is it related to the things that we're talking about? The statement of measurable annual academic and functional goals. So we're going to be talking about that. We're going to be thinking about that in more detail. That's the key. That's the guts. That's the guts of what the laws give your child. That's the thing that you should be able to, that you can sue about, right? If it's not given to your child. This is where you're negotiating the contract with your school. This is what they're going to be doing and giving my child, where they're going to be doing it and giving it. And if the school doesn't do it then you have the right to sue under the IDEA, theoretically. And then a description of how the child's progress towards meeting the goal is going to be measured. So that a year from now, when you look at this again, you know where you started, you know what they're supposed to be doing, and you have measurements. You know how far your child got. These are the three things that the law requires. These are the three things that are typically not there. Just keep that in mind. That's what you need. Where did he start? Is there enough in this little piece of paper that I just moved on? It tells me where he starts, what they're going to be doing, and is there a plan for us testing whether he's getting better at the reaching the goal that he's getting? And then there's a statement of services, which is the actually where the child is going to be served, like in a which classroom, and what the child is going to be given. What kinds of therapies the child is going to be given, what kind of support the child is going to be given, what kind of special modifications to learning are appropriate. And they have to be relevant to the goals, right? They have to be appropriate to the goals. And they have to be tied to the regular general education curriculum. So even if your child is in a totally isolated classroom, the services have to be aimed at trying to let the child make progress in general. And they should also be talking about how the child is going to participate in extracurricular and academic services in that school. Because, like Andrea said, education isn't just seen as understanding the academic things of math. It's preparing the whole child to be a functioning independent adult. And that means learning how to be on teams. That means learning how to interact with other people. It's all that is relevant to what you might be wanting to get for your child. It's really important then to going back to what Andrea says, to make sure that all of the educational needs are in the evaluation, and if anybody found in the evaluation are addressed in the IEP. That means going through that evaluation and color coding. Oh, there's this need, there's this need, there's this need, and then looking, okay, where in the IEP are we addressing this need, and this need, and this, and often you won't find it. So that's what you do at the IEP meeting. You have time to be looking at all of this stuff. One of the things you're doing is, okay, but they also said that you had an auditory processing issue. Where in the goal is that being addressed? Where are we working on that?
We see in the clinic all the time for IEPs or evaluation reports where something is identified as being a need, and it goes fallow.
Yeah.
Years go by and nobody's addressed the fact that the kid cannot act or whatever.
Even throwaway stuff you don't think it's an issue for your child right now. If in that review they address it as a need, you want to bring it up, you want to get that somewhere in your IEP. Like math, and I think for a kindergartner, that's important right now. Why worry about it? But if they recognize something, then they're pre-math skills that should be being worked on, even when they address. Anything that can be approved requires a measurable annual goal, and the measurable goal has to be appropriately ambitious in light of the child's circumstances. There was for a long time a set of evolving laws that basically said if a child makes any progress, it can be de minimis, any progress that satisfies the IEP. And the Supreme Court, bless their souls, came in 2017 and they tightened that up a little bit. They said, no, there has to be something more than de minimis. There has to be progress that's appropriately ambitious, that pushes your child, even, and there's language in this case, in your case, even the child who's really the most limited can make some progress and has to be tied to the eventual goal of independence. So thinking about that when you're looking at the goals that are in your IEP, be ambitious about, and that's push. That's where you say no, I don't care if my kid's in the low IQ classroom. He can learn how to read, and if we're going to have a goal, he's going to be learning how to read. I want him to be able to read at the next grade level by the end of this grade. We don't make it, fine, but let's try it, right?
And the court didn't tell us what in light of the child's circumstances and needs. Yeah. So it could mean, that kid's really low functioning. We don't expect much. But it also could be, this kid has a lot of needs. He needs a lot of really work hard for this kid. We don't really know. What it is. Arguable at it, right?
Right. So anything that can be addressed, it has to be addressed in a goal. If there are things that just can't be addressed, then you've got modifications. Right, or they're gonna take some time, then there should be modifications built into the program to allow the child to go to the extent possible. It's not can be addressed. Okay, I think that we're back to you.
Yeah. So, so we're talking about things that can't be improved, and I can't tell you what those look like. You need somebody who's a specialist to tell you that. So what Rich Ziegler would tell me is that processing speed cannot be improved. I assume he's correct. I'm not a neuropsychologist. So that's the kind of thing that we're going to be accommodating with program modifications. Or sometimes we know it's going to take a really long time for a kid to read a grade book for something, you know, a particular kid. They're that far behind. So we're going to have to accommodate that or create a program modification at the same time that we're delivering services. And this is just a graphic. You see it all the time. I really like it a lot because I have a lot of parents and kids, even my own kids, who said, you know, it's not really fair. And this is I think the graphic that shows you that fair and equal are not the same, right? So everything's equal on the left side, but some people are left out. Everything's fair on the right side. And so everybody gets to start at the, you know, start the race at the same, at the starting. So the way that we determine, or the way we fulfill the obligation of the United States Supreme Court to demonstrate that the child has made progress appropriate in light of the child's circumstances is to measure progress on goals and objectives. And this really is, it's just about the heart of a child's educational program. And because progress reporting is so critical, because you know, a failing program or a successful program has everything to do with how much progress a child makes on goals and objectives. Goals and objectives must, in fact, be measurable. And you hear that trotted out constantly as a phrase, but I have never seen an IEP that contained only truly measurable goals. So goals that have to be written concretely. Better isn't a concrete term. You're looking for numbers and you're looking for units. If progress is the most important thing to us, we have to know where the child starts. So if I say the child's going to progress to being a 4th grade reader, I have to know whether the kid is already a 4th grade reader. Because if the kid's already a 4th grade reader, there's no progress. If I say I want the child to increase the number of words that he can read correctly in a minute by 15 words a minute, I need to know how fast the child can read well or now. So whether it's in the section that describes the child's present levels, as Lisa described, or directly in the goal itself, we have to have initial baseline data. We can't measure progress, or we'll be delayed in measuring progress, right? Because then the first time we measure progress, that will become our initial baseline. So we might go months without knowing where the kid started from. And we have to know where the child is going. Again, better won't work. We need to know how many words per minute, what grade level, you know, how many times the kid pinches his neighbor. We have to have, again, a standard that's measurable, and they have to match, right? Yeah. So we can't talk about it. We see a lot of this. Yeah. You know, because it's silly when we'll say like, the goal describes how fast the kid can run at baseline, but the master standards involve how fast the kid can ride a bike, right? Well, that doesn't help. So they've got to match. You're measuring apples to apples and oranges to oranges. So goals and objectives should be measurable at the time of writing. And the reason is that lots of people are going to be working on your child's educational programming, and you're going to have an idea about what a goal says, and another person may have a different idea. And you don't want people, interpreting things in their own way. So as lawyers, we're really at an advantage, right? Because we're trained to think of all the different ways that language can be interpreted. My spouse is a salesperson, so he's like, it all means we're selling something, right? So he just thinks like whatever he's thinking in his head is the thing I'm hearing, and gets really frustrated when I say, well, that could be 3 different things. So you don't want 3 different practitioners measuring 3 different ways, teaching 3 different things. So everybody sitting at the table should know while you're sitting there exactly what the goal means. So they have to understand what the skill is. A lot of times we will read goals and objectives and think, I don't even understand what the skill, what the kids got learn how to do. Does everyone understand exactly how progress will be measured? And does everyone understand the conditions under which data will be taken? And that's an oft ignored issue. So if we want, we mostly deal with kids about reading issues. If we want to know how effective a child is as a reader, we want to know that child is, at least when we test that, we want to know that the child is reading a passage of the same length each time. We want to know that that child is reading a passage at the same grade level each time. Because you confound the data if you don't hold those variables steady. We are essentially, some of you will remember the scientific method from when you were in junior high and in science class. This is you're running a science experiment, right?
So in our recent IEP meeting, the fresh undergrad special ed manager said, well, I conducted this and it was right during a period of time where it was before he had to go to lunch, and I think he was really distracted because of my question is, what do you get to, as a parent, get to demand of the school to say, do it over again? Because I don't think it's accurate. Like, well, what do you get to do with that?
Hopefully you put the conditions of how he's going to be tested in there, and you're going to say, it doesn't mean that conditions don't have to do with it. Or, oh, so you're telling me he was hungry, then this wasn't really on the test, was it? You can say, no, so then you have to do it again.
One of the highest values in the idea is that parental ability to participate in educational decision making can't be impeded. So if you have bad data, your ability to participate is impeded. But Lisa's right. You want to try to nail everything down at the beginning. And we'll look at an example of an evolving goal so that you can see how goals can be really, really terrible or really, really excellent. Long goals aren't the goal, right? Because we see a lot of long goals and they're crazy, but highly deep, you can almost not be too detailed. And school districts don't get confused. They say, am I only supposed to teach him, in the library from 2 to 2:15? No, you can teach him whatever you want. But when you take data, do it in the library at 2:15 every time, right? Don't do it as he's transitioning from lunch. Don't do it as he's, then the next time in morning sharing time. And then when he's on the bus, just take it all under the same conditions. If we were all researchers, if we were all science majors, we'd all be going, duh. But that's a really hard concept for a lot of folks.
So are we talking about taking this data as part of that evaluation that happens every 3 years? Or is this separate special data?
It's not the evaluation.
Okay, so the
Plan for how your kid is going to learn, right? Contract that you wrote, these are the goals, and then they're meaningless unless we can measure, is he actually making progress on these goals? And we have to have these measurements.
And so like a special education teacher takes them out and measures these, or like, okay.
Yeah.
Or speech therapist, or
Yeah, kind of depends on what the goal is,
Yeah.
right? But the law says, they have to be measurable goals, and then you have to get progress reports. And they're meaningless most of the time, but everybody should want that data, because maybe this intervention isn't working. And after you try it a few times, maybe you'll have an idea to try something else. So maybe it worked so well, we don't even need that as a goal anymore next time. That's every time you have your next IEP meeting, you don't have any ammunition unless you have data.
That's exactly right. So you want to typically see this kind of information in an evaluation that's dealing with identifying broader needs. So a child has a math concern, you know, something about the level that the child is at in terms of, their grade level of math skills. But now you're gonna start working on things that are goals and objectives. I'm going to write, an addition goal or objective. And so if, you know, if we wanna know in that discrete skill that's being measured as an addition, how at the beginning of the test does he perform? And how at the end of the test, if you will, does he perform? Because Lisa's right, that tells you, oh, this has been an ineffective intervention, or this isn't working, we are gonna have to make a change. So here, yes, go ahead.
What is reasonable for how often you get progress report?
You get it, you have the right to progress report every time you have a kid who's going to report card. But if you think there's something going on with your kid that you need more frequent reports, you put that into the IEP, because the IEP has to say how often you get your progress reports. But you have a right to have them whenever everybody else is report card. And that's how, and what the law is talking about is how often you get a progress report, but that is completely separate from how often the school district takes the data, right? So you might decide, you know, like kids who are on, or Gillingham reading programs, they take data every single day, right? Think about how often you get data from Rose. They're always taking data. So I know something about that. So all right, so this is a progression of really, really bad goal to what I would consider a sort of gold standard goal. So the first iteration is extremely common. Jack will go from reading aloud slowly and stumbling over words to reading a more age appropriate rate. It's qualitative, not a quantitative description. Very, 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 very common. Jack will go from reading aloud slowly, stumbling to reading at a rate of 75 correct words per minute. That's also very common. So we've got some indication where we're going. We have no idea where we're starting. 3, I would toast the reading teacher if I got 3. Jack will go from reading aloud at a rate of 50 correct words per minute to reading aloud at a rate of 75 correct words per minute. If you have a skilled teacher who says, you know what, we're always going to have to do this under the same conditions, that would be enough. But you can't assume that. So that could be a good goal, but you can't assume it's going to be. Jack will go from reading aloud at a rate of 50 correct words per minute on average to reading aloud at a rate of 75 correct words per minute on average in 3 1-minute probes. It tells me exactly how every time they take data, how often they're going to do it, and how long they're going to take data. So now I know that the school district is being held to an even tighter standard. The kind of data they collect is more likely to be useful. Because think about what the alternative is. We did it once. Well, that's not statistically significant. Well, we did one for, a minute, and he did pretty well. And we did one for 5 minutes. And I didn't do quite so well with that. And all gets sort of mushed up together, and nobody knows how well is this kid really doing. This is a very tricky issue that really messes schools and parents up. Jack will go from reading aloud at a rate of 50 words per minute from a 4th grade primer, because I really want to know what's he reading, right? I'm sorry, from a 3rd grade. From a 3rd grade primer at 50 words per minute to reading aloud from a 4th grade primer at 75. Well, he would definitely make progress. Right? He would. But the problem is that baseline doesn't match my mastery standard. I don't want you switching up the material in the middle of the ministry. You can teach him out of the 4th grade primer. I don't care if you do that. But when you take data, use the same material every single time. So the trend makes sense. Right? Finally, I've never seen anything like this, but this will be very little to chance, right? As a parent, I'd say, you know what? Everybody who looks at my kid, takes data, is going to do it in the same way. And the information I'm going to have about whether he progresses is probably going to be revealed. I've never seen anything like that, but that's what we try to create in the clinic for our students. Next one, right? That's my.
So just so you guys know,
when we started teaching this, we used our own kids' IEPs as examples, and we were just. They were horrible, they were so horrible. They had, the first line is what you'll see, that came from our kids' actual IEPs, and we were proud of them, we thought they were doing a good job. Until we started teaching this, just so you know, okay? And it's, and also you're gonna, what you're gonna hear from people, like, you know, you're gonna hear, we don't intend to do that. Oh, well, or when the person goes, yeah, but then the person who was trained to do that, she left, she's on maternity leave, so the janitor came in and did everything. And you just have to say, well, oh, then we just didn't do it right? Then we just have to do it again, do it the right way. You can say that pleasant, but you keep insisting on it. And not we did that, we're not preaching what we did. Do as we say, not as we actually say. Oh, yeah, we did it. So this is, the next one then, this was my, my son, Peter will use appropriate behavior to be heard, i.e. raising hand, waiting his turn in group settings, 90% of the time in 4 out of 5 occasions. I see that, oh, numbers, great, okay, that's a measurable goal, but it's not 4 or 5, like when, why, it's 90% of the time, and where did he come from, right? Where did he start from? Maybe he was doing this already, and then they just put that in there. So a better one, and not a graphic, like, raise his hand, could be raising his turn. Well, which is it? Like, and this is stuff that you read this up the first time, you can barely actually say, you know what they're doing. But you guys know how to read, and you're all warriors, and you know when, standards are switched in the middle of a sentence. You know when there's too many things going on in there, and you can use that skill. You can use that skill. You just ask them, what does that mean? And then eventually, and then they'll say, well, it means this. Don't worry, we understand that. No, let's write this then and add it into the IEP. So anyway, this will be a better one. Peter will go from raising his hand and waiting to be called on before talking aloud more. Sharing time 60% of the time. That's where we started. On 4 or 5 occasions, so doing the same 90% of the time. And it will be measured by the special education teacher each school day during a single week. So they're going to spend 1 week when they're going to do this, right? And checking them out. And then that would be your progress report. That would be good. Another one, Andrew. Okay, Andrew needs to improve his alphabetizing skills to an age-appropriate level. So why is age-appropriate the right thing for this guy? Because whatever his deficits are, right? We never even know what those. And then how are we gonna? Okay, yeah, he does. We all agree. We do need to improve them. But how do we get there? How do we get there? Age-appropriate level means nothing but here's numbers, right? There's numbers, and it tells you how often it's going to be measured, how it's going to be measured. So that works much better. I'm going to, in the interest of time, just kind of skip through a little thing that you're all too young to need yet, but it's good to know it's going to be coming. There's going to be this time when your kid is ready to is 18, and under the special ed laws, they're allowed to stay in school another 3 years till they're 21. And before the kid turns 18, they'll start doing, when they're 16, they'll start doing transition. And you get really scared, because it really means start thinking about your kid as an adult, what they're going to do. And so I'm just going to skip through this. It is something that you have to, that you'll have to deal with when the kids are any of you close to 16?
Well, I just want to say the federal law does provide that you're supposed to be till you're 22.
Right, yeah. You have to be 21, like when the school district starts, something like that.
That's what Minnesota provides.
Yeah.
Federal should be through 21.
And some kids, it's not appropriate for them, but some kids it is. And these are the kinds of things you can start thinking about when the kid gets to that age. Part of the schooling, remember, is the whole kid. Can they operate independently? So this is when you'll start doing things like this, voting, grooming, counting money, all kinds of stuff like that. Okay, and they have to be measurable, be concrete. But by then you'll be old hands at this. Beware of services in this transition period that parents are expected to provide instead of the staff. Yeah, you'll teach them how to drive. Maybe not. Goals and objectives that consist of completing interest surveys or researching college interest requires that doesn't really do very much as a goal or objective. That's one of the things they should be doing. That's not a goal or objective. transition goals that are no different from regular academic goals. You gotta think a little bit different once you're in transition. You again,
Me again.
you again.
So
There was a.
yes, I also am going to move fairly quickly through these sections. So you've got these goals and objectives you've written, and now you have to think about how you're going to support them. How is the child going to realize progress on the goals and objectives? And they're going to do that by receiving specialized instruction, which means that the instruction has been modified in some way in its delivery or methodology to meet the child's individualist needs, and then related services, which can be transportation, speech, physical therapy, augmentative services that will complement the special ed services that your child needs in order to realize progress on goals and objectives. Interestingly, one of the things that many of our parents need is a related service that is I've never seen addressed, and that's parent counseling and training. So when you think about how you're at a loss in terms of what your child's legal needs are, you could justifiably say, I need parent counseling and training in the area of my legal rights or my child's legal rights. Services, these services are always driven by need and not availability. And you aren't going to know what your kid needs, right? You're not a specialist. The school district is going to come with what they believe your child needs. And they should be able to defend for you how they know that's the amount and kind of services that are going to result in progress for your child. In Andrew F, the case that Lisa talked about, the court says by the time you get to litigation, the school district should be able to offer a cogent explanation and responsive explanation for its programming decisions. Don't wait that long. Demand that initially. If they can't explain to you why they think your child needs X numbers of minutes per day of whatever kind of service, that's troublesome. The resolution, like the resolution so frequently is an expert on how much service your child needs to make the kind of progress that the law describes or requires. Educational placement, the most important thing to know about educational placement is that it's one of the last things you can do. So it's always given the kid's going to go wherever the school district wants your kid to go. It's based on your child's needs. It is a group decision, although we all know that frequently you're the lone voice in the wilderness saying, I think my kid should go to the neighborhood school, and the rest of the team is saying otherwise. It's as close as possible to your child's home. It's a school that he or she would attend if not disabled. And it's in the child's least restrictive environment, which means the child is going to be educated to the greatest extent possible with kids who do not have disabilities. And we only consider taking the child out of a maximally integrated setting when the use of supplementary aids and services in the regular education setting isn't enough in order for the child to make appropriate progress on his or her goals and objectives. We won't spend much time on the Rocker test, except to say it is what we use in the 8th Circuit. It's well understood, where you will typically see there are different circuits use different kinds of tests to determine what it means to place a child in their least restrictive environment. But it is not uncommon for kids who have behavior challenges. I'm going to just commit to keeping the water in one place. I'm unable to do that. It's very common for school districts to not have the skills to address a child's behavioral needs. There are people who have the skills, they're brilliant, they're called behavior analysts, certified behavior analysts. If you have a child with a behavior problem, that's what you want. So there's a tendency to try to further segregate your child. Let's move your child into a separate school or a separate room. And as an attorney, the question I have always asked is, what do they have over there that's better? What do they have over there that's special? It's going to meet my child's needs more effectively, and nobody has ever been able to tell me. And that's, I think, the most important part of the Rocker test. which is you have to know what's so important over there. So you can figure out whether it can be imported, into the setting where your child currently is. Most of the things we've taught you to say will makes the school district employee look at you like you grew multiple heads, right? This will all use. I'm sorry, I can't see your, oh, right next to Chris, sorry.
I was just gonna ask if behavioral analysis or behavioral analysis is what they need at other setting. Do they
Almost
have to
never.
provide it?
Yes,
Their.
yep. Whether they work there or they don't. work. Yeah, but they almost never have those.
The parent decides it's best for the kid to move to a setting for environment. Does the district still have a duty to go through like the whole process and tell the parent, no, the setting 3 is more appropriate, or it's all in the parent's hands to actually decide if it's a setting 3 or setting 4 environment?
I think it is the school district's obligation to ensure that the child is in the child's least restrictive environment. But, and they could, if they felt very strongly about that, take the parent to hearing. But they are unlikely to do so. Most schools would be very happy to see kids in restricted settings and regular kids in other settings. When must the IEP be in effect? That's got to be done. It has to be done. They have to hold a meeting within 30 days of determined placement. Usually these things happen pretty fast. I don't generally see that as being an issue. Once a year, the school district will consider whether the IEP is still appropriate, whether it needs to be modified. It is supposed to be the case that location or placement is reconsidered at that point. As a general rule, kids continue to stay where they are unless there's a compelling reason to remove them. Did you confirm that?
So we've already talked a lot about progress reporting, and that really is the key, the key to knowing whether or not your kid is, it's working. The plan you put together is working. And the IEP, so the IEP, we talked about that, has to describe the progress, and when the periodic reports are going to be provided, you have to provide them at least as often as they provide report cards. And the progress reporting has to be concrete, responsive to the baseline, and it's often not. Right. It's often measuring apples when you said you want to see whether you want to see. And you can read that and you can tell that, you can ask them. I like that. So just be alert to when the progress reporting is due. And if you think that there's something going on, you want progress to be measured more often than the reports are given, be aware that that's a difference, right? And you can ask for more frequent progress reports if you want to, but the only thing they're obligated to do is give your progress report every time they get report cards. Insist that they report on all the goals and objectives. So everything that you put in there, don't let them lose something about it. Progress report is due, go through, color code again, find every goal and ask where the progress is on that goal and objective. Don't rely, this is one of the forms you'll see. Insufficient progress or adequate progress with goal map, there's a C or goal X. That's not enough, right? Adequate progress, what is adequate progress? You need some numbers, you need to know why they think that's adequate. Right? You don't know. It might be, but you just need to know what other coming to that conclusion. And they're all really busy. I know they're all overworked, but you have the right to depends. You're getting your sitting. You have to be making progress, right? If your child's not making any progress, the IEP has to be readdressed, has to be changed. That's the key to the whole program. Right? That's the key to whether or not your child's education is meeting his or her needs, whether they're getting better at whatever it is you've identified in your IEP. It can be improved with the tactics and the placements and the services that you were guaranteed. You can measure it, you don't know what's going on, right? So here are some actual goals and progress reporting that we have seen in different situations.
remember who's supposed to.
I think, do you want to talk about this? I think this is me, but I think
Go right ahead.
we're not gonna work on it too long. We're getting close to the end. And honestly, we could spend another hour, right? But this is actual progress reporting on my son's IEP. My son is, and I'll tell you that I chose these because they really matter. He's, as I said, he's a super smart kid. He can't graduate from college. He'd like to be an entomologist, can't do it, mostly because his executive function is so poor. And so getting, crappy transition roles, which is what this happens to be, well, I sort of, in a sense, has a real impact on his ability, not self-supporting. He works at UPS part-time, which is a perfectly fine thing to do, but it doesn't pay the bills, so we pay the bills for him. And it wouldn't have to have been this way. So you have a bad goal here, we don't have any baseline information. It's got a variety of problems that include the fact that this is a composite goal. So there are different things, different skills being described. So determining the homework that needs to be completed, completing the work, and turning in the work are all different skills. He probably has different skill levels for each one of those. So he probably needs baseline data for each one of those skills. And each one of those skills probably should be measured. We're not going to have good information about where he's struggling and where he's doing well. But what you'll see is there are no data in this progress report. I don't have any information, it's all narrative. That is the only progress report he received in 9th grade. He was in St. Paul. They had 3 progress reports per year that children received. He only received 1. In grade 10, the progress or the objective was repeated. The library was decreased. It was repeated but decreased. Thank you. That's really a sign that things are going on, right? It's been repeated, but our expectations are being dropped. Thank you for seeing that. Instead of thinking we've got to really boost his services up, or something's not going right, maybe it's more evaluation. Something's just not working here. Instead, it was let's lower our expectations for this kid. And I was a disability rights attorney at the time that I was in special ed. I worked in housing and I worked in public benefits, and I got no progress reporting on this objective, and I didn't apparently care. And so you have these, I assume you have access, Gloria, they'll have access to the PowerPoints if they don't already.
You send them to me, I'm sure related.
Okay, so you can see it's just a bunch of examples demonstrating, including Pete's here. Where we lack the bad goals, which is really the emphasis here, but it is what it is. And then again, Pete has no information, or we have no information about concrete information. And even if somebody tells you, you're right, if somebody tells you things are going well, and they always tell you things are going well, you can't be an informed member, you can't make informed decisions about your child's education. And the idea rises parents' ability to be participants as educational decision makers. Common report, should I just keep going? This is me. Oh, so sweet. You're some of the Downs kids, right? Oh, he's just a joy. He's just a joy. Miriam works hard. Yes. Are you the ESY gal?
So this is one thing that you should be aware of.
Oh, you're all right. Okay.
So we're out of time, but extended school year, you'll be offered typically a little program that will, if your kid wants to go and learn how to clean rooms in a little house, an apartment, and go swimming every once in a while, and home with his friends, 6 weeks, and the school district will say, that's what we offer. And that's just wrong. Extended school years of service is also part of it. If your child can prove that they need extra to continue their support during the summer, so they don't backslide, then that's what you fight for. And it should be treated just like the regular school year. There should be goals, there should
Or if
be.
their progress is inadequate, if their progress is
Inadequate, if you've gotten your study reports and they haven't, he's not filling out his journal at all, or his letter, then he needs help doing that with some, he doesn't need to go and run a vacuum in the room with all the other, kids.
So just like special ed is all individualized, if somebody tells you this is our ESY program, they buy it.
So anyway, that is about it. Are any of you on 504, section 504 offense? It's like an alternative to idea, so. Okay, that is it. I'm sorry if we ran out of time. I hope you got something out of it and we can build on it. If we need to make do another one of these with advanced.
So much.
Thank you.